We'd just like to offer a welcome to all those who are attending. So far, I think we have about 50 people. We're expecting somewhat of an international audience, although the majority of individuals will be here in Canada. And we're going to be presenting as an expert panel to all of the groups. So just by way of summary, we're going to have more or less a group of accountants and lawyers, as well as business owners, many of whom have connections or family members or perhaps clients that are located in various jurisdictions, and also clients in Canada. So the focus of our program, for those of you who are already joining us, will be primarily to deal with how to achieve asset protection in light of some of the challenges that are facing individuals both in Canada and abroad. I noticed that we are starting to increase a little bit as far as the attendance is concerned, and it's now a little after 1 o'clock. So I'll have Jeremy give an introduction as to what more or less we're going to hear, and we'll introduce the group. Jeremy, go ahead.
Good afternoon. My name is Jeremy Louie. I'm a tax associate with Quantum Business Law. I would like to welcome our international audience today to our Tax Structures for Canadian and Foreign Investors webinar. For your benefit, we have assembled an international panel who will be providing timely advice on domestic, multinational, and international tax and other financial issues in a world in economic crisis. To that end, I would like to introduce our expert panel, starting with Todd Louie. If you please introduce yourself.
My name is Todd Louie. I'm a partner in Quantum Business Law. I've had the experience of lecturing to thousands of tax experts, accountants, lawyers, business executives in various cities across Canada, the Ontario Bar Association, various different tax publication programs that I've been part of. And I intend to offer suggestions on how to achieve asset protection during the COVID-19 crisis on an international basis, as well as here in Canada.
Thank you, Todd. Lauren Saltman, please.
Hello, everyone. I am a tax lawyer and I wear a couple of hats. One is as the head of the tax group at the Toronto law firm of Gardner Roberts, and another involving a family office internationally. And in that dual capacity, as a tax lawyer involved in domestic and international planning, particularly for entrepreneurs, private companies, and families, I'm more and more deeply involved in asset protection, in effective tax planning to minimize exposure, particularly with the opportunities today in the economic crisis of restructuring and organizing one's affairs.
Thank you, Lauren. John McLeod, please.
Thanks. I'm the chairman of a group called Ethicus International, which is a group of international trust companies around the world. And I'm also I'm a resident of Barbados, although I'm a Canadian. And I'm a member of the board of the Forvest Group, which is a conglomerate of financial services companies headquartered in Switzerland. And my mandate with the Forvest Group is that I am responsible for all of the North American businesses of the group.
Thank you, John. David Lesperance, please. Oh.
Unmute him.
Sorry, David, you're muted there. Can you unmute yourself?
You just remuted yourself.
I was just saying, going through law school, I worked for Canadian Immigration, and then in 1990, I either saw the light or went to the dark side and got called to the bar in Ontario. In 1990, my law school study partner went to Hong Kong and started referring clients to me who were looking for backup plans in anticipation of the 97 handover. And then my client base later expanded to include clients from China and other countries in the region. Also during this time, I started to travel through the Gulf, meeting private banking clients of Standard Chartered Bank and British Bank of the Middle East, which is now known as HSBC. This was before, during, and after the Gulf War. This gave me insight into the needs not only of Gulf nationals, but the other residents, such as non-resident Indians, Pakistanis, Lebanese, Palestinians, Iranians. And then in 1990, I assisted my first wealthy American to legally leave the US tax system by formally renouncing their US citizenship. The US is unique in having citizenship-based taxation. And since that time, I've assisted several hundred wealthy American families to either have the option or to actually vote with their feet. So as a result of these and other client activities over the past 3 decades, I describe myself as either a tax-savvy immigration advisor or an immigration savvy tax advisor. And it's this holistic perspective allows me to work with people that are on this webinar, such as Todd and John and Lauren, to develop what we call backup plans. And it's this integrated approach that we hope to bring you during this webinar.
Thank you very much, David. Now for our other David Yanaglu, please.
Hello all, my name is David Yanaglu. I am a corporate development executive in the software space, but rapidly expanding to other points of interest as well. And I'm joined this wealthy group of knowledge that are my co-panelists, and we're excited to present to you tax-based approaches to real-world issues that exist today.
Thank you very much, David. Do you know if John Yanaglu is available? If not,
let's pass him. I think and then we can go on.
Okay, we'll start our program.
Yeah.
So now I'd like to call upon Todd Louie to introduce our themes for today's program. Todd, please.
Well, thank you. Thank you very much. And John, if you are able to hear us, and I know that you're joining our program partway through, then please speak up because we'd like the opportunity to introduce you. The Quantum Tax Law Consortium has been expanded, and we will be launching another focus, which will be intended to assist international clients in various different jurisdictions. And John's wealth of experience, I'm sure, would be very interesting to all those in attendance. So just speak up, John, if you're able to hear us. But in the meantime, I'm going to talk a little bit about the fact that many in attendance today have attended our educational programs for accountants and lawyers and for business executives across Canada. And I don't know if you had recalled the timing of things, but just after COVID-19 had become a crisis, our group immediately jumped into action in order to provide defensive measures for wealthy Canadians that was essentially premised by the fact that Canada is becoming a country that doesn't necessarily have debtors' interests at heart. What do I mean by a debtor? That means anyone who's a subject of litigation, anyone who's a subject of attack on assets from creditors. And in effect, one of the focuses of our consortium for quite a long time has been to say, how do we achieve superior asset protection, whether it be for international clients or clients within Canada? I know that many of those in attendance today have taken the advice of our group and have undertaken measures such as estate freezes. You've set up trusts both in Ontario as well as in Barbados in order to achieve superior asset protection. And we've had calls from individuals and said, look, the program was great. All of our big clients, or we had business owners say, we have already done an estate freeze. We've already done this planning. Well, interestingly enough, when we work through these situations, we find issues where companies, although they have done an estate freeze, what they've done is they've left behind assets inside of their company that may be causing problems. And oftentimes they're not aware of it, or they haven't actually taken the step. And what many companies are not aware of is the fact that surplus cash and investments can actually cause the loss of the capital gains exemption. Business owners, accountants, and even lawyers are often surprised when they realize that some of their clients haven't necessarily looked underneath of the balance sheet in their company to say what kinds of assets are there, and are these assets vulnerable to litigation? And often they are. And also, if you've done an estate freeze, have you caused the loss of the capital gains exemptions on numerous different family members? All of those things are disconcerting. So we're inviting those to think again. If perhaps you're thinking that you've already done an estate freeze, you've already done inbound planning, and you believe that there's nothing much more to do, there is so many things that we can help with as a group. Jeremy mentioned that we've assembled this group of international experts. We have a tax lawyer an immigration lawyer from Poland, and we have a world-renowned group that involves finance experts, both from Canada as well as Barbados. And what we're here to do is we're here to help in a number of ways. One of the things that you're going to be hearing about today is the calamity, the crisis. Wealthy families are under siege in various countries, both from the point of view of their personal freedom and also their assets. Individuals who have accumulated wealth are concerned that their assets may be taken in some way by government officials or otherwise by claims against their estate after they die, or some other unsightly event that may happen. And you're going to hear a lot about the type of crisis that individuals in various countries are going through today that we may be somewhat sheltered from. And you're going to be able to see that there is a need indeed for individuals to be able to enter into a structure where they either invest in a stable economy, such as what Canada has to offer, or perhaps even consider migration to Canada themselves. And there's a number of different things that we're going to be providing as far as ideas on structures to allow individuals to be able to safeguard their assets and to invest in an economy that is a little bit more dependable than it is in many places of the world. The other thing we're going to be talking about today a lot is asset protection. Beyond that, beyond where people live, beyond the kinds of political instability and economic uncertainty that faces the world. The other issue we're going to be talking about is the use of trusts. And we're going to be getting an incredibly good description of both of those two things, but the latter being the trusts. I would start off by saying to you that many in attendance today are joining us from civil law countries, whether it be Mexico or other countries in Latin America, countries in the Middle East, perhaps Europe. Well, one thing that all of these countries have in common, whether it's Latin American countries, some countries in the Middle East, or perhaps China, is that they're civil law jurisdictions where trusts, the law of trust is not very well established. Well, we're going to be talking a little bit about the various different methods that you can use trusts, and also the Hague Convention, which has now been subscribed to by 14 different countries since 2017. And the issue in reality is that many of these wealthy investors that are joining us today may not be terribly familiar with trusts. And therefore, we'd like to shed some light on how trusts can be used in order to achieve asset protection. You're going to be understanding what trusts are, when do you use them, what are the benefits, how can you deal with certain issues. I'm going to talk a little bit about the reasons that people might consider trust. Well, one of the reasons is that they may be considering, as I mentioned before, protection for those assets perhaps in another jurisdiction. There's also succession planning. Second generation, third generations that are coming into businesses that are located where assets are held in these jurisdictions, with a goal to being able to essentially transfer these assets intergenerationally. The other thing is that as people get older, it isn't uncommon, although it's not pleasant, there's loss of mental capacity, where an entrepreneur located in one of these countries, or here in Canada for that matter, may not have the mental capacity to make certain decisions. And of course, there's planning that can be done through the use of a trust that might be beneficial. Oftentimes we see situations where the older generation will stay home and the younger generation will decide to migrate to a jurisdiction such as Canada, but not necessarily Canada. And in that case, trusts can be used for that purpose as well. Many individuals are concerned with vulnerability to litigation, things such as breach of contract or negligence suits. In civil law jurisdictions, there's also forced heirship laws that exist, where there's an automatic entitlement of family members, whereby a trust can be established in jurisdictions outside of, say, one of these civil law jurisdictions, whether it be somewhere in Europe or Russia or wherever it might be, whereby the civil laws dealing with forced heirship, in fact, may be defeated in a way that the wishes of the entrepreneur can be achieved through the use of a trust and by being able to navigate. So what we're saying is that trusts provide an incredible opportunity to protect assets. Our group had recently the opportunity to assist a couple of individuals, all of whom had assets in the hundreds of millions of dollars, where we were able to assist to ensure that the viability and efficacy of a trust is protected in situations where assets would have been entirely wiped out if the individual hadn't been able to establish a trust in places like Barbados in order to achieve that. And again, we're not talking about risking assets, we're talking about protecting them. And typically, you'll find as we go through our description, use trusts outside of Canada. The purposes and some noise on the line, I'm not sure what that is. The purposes of the trust is essentially intended as a holding instrument where we're not sending money outside of Canada. We establish trusts only. To that end, I'd like to have David Lesperance talk a little bit about the kind of calamity that individuals are facing in various different jurisdictions outside of Canada. David, we'd like you to illuminate, if you don't mind, on the kinds of problems that non-Canadian residents are facing and the reasons that such individuals, perhaps individuals that are associated or acquainted with people on our program today, may be interested in either investing in Canada or perhaps migrating here. David, if you'd like to please tell our audience a little bit about the background that are affecting individuals outside of Canada.
Sure, thanks, Todd. And as you said, I want to talk about three topics today. So the first one is kind of the geopolitical and economic issues that are affecting wealthy families around the world. The second is why some of those wealthy families are considering Canada as a place to have an alternative residence. And finally, why Canadian residents, people already here, may want to consider having a backup plan. So on the topic of global events or trends impacting wealthy families, in 2018, I published a paper about the wisdom of backup plans for high net worth families. And at that time, I listed some of the risk-inducing events that had dominated 2017's news cycle. And these included multiple category 5 hurricanes, North Korea nuclear threats, the US-China trade war, Brexit, the election of a socialist Mexican president, economic political gridlock in Brazil as a result of the widespread corruption investigation, and MBS, new Saudi leader, arresting hundreds of royal family members and basically holding them up and seizing almost $1 trillion worth of assets. Well, now it's 2020, and most of the 2017 threats have not been resolved. Indeed, most have gotten worse. Meanwhile, over the past 2 years, several other threats, such as the unrest in Hong Kong and the security bill, have emerged to make the world even more unstable and uncertain. However, the most notable new threat is, of course, COVID-19. And if you consider the risks above that I previously mentioned, they more or less fell into one of 5 categories. They're either political or legal, economic, social, technological, environmental. But what makes COVID-19 different is that it will impact not 1 or 2 categories, but all 5. And some governments are using this pandemic as an opportunity to dramatically increase government control, for example, the security bill being imposed in Hong Kong right now, or to push forward previous tax the rich agendas under the guise of we're all in this together. That's everything from the Democrats in the United States to Labor in the UK. So in all cases, prudent wealthy families recognize that these interesting times are also uncertain times, and they're seeking the comfort of a backup plan. And in fact, one of the follow-ups that we'll have is a very detailed paper on how to actually look at and construct a backup plan, which we'll send later on, so I won't go into great detail there. But the wealthy families have a range of reactions to these threats. Some are immediately relocating their current main home and moving their assets to safer locations. Others are setting up alternatives just in case conditions work. Which is appropriate depends completely on the family's situation and fears and goals. But what is undoubtedly true is that many are considering Canada as part of their backup plan. Canada is a popular choice because it's a low crime, rule of law country with decent infrastructure, including education, medical facilities. It's an immigrant country with a legal regime and a bureaucracy which is able to actually process immigrants who want to come to Canada. It can offer an alternative residence very quickly in the form of a work permit, and this can be extended to permanent residence and then citizenship as soon as 3 years later. Canada is close to, but not part of the US, and this allows wealthy families to partake of those personal and business opportunities that they find attractive in the US, without having to deal with some of the unattractive elements such as taxation, litigation, and their reaction to the pandemic. Canada does not have an estate or a wealth tax. That's important. And those seeking citizenship can use legal pre-immigration tax planning, which significantly reduces their income and capital gains tax burden to below those normally paid by tax residents of the US and the EU. And Lauren and Todd and John are really going to discuss this planning later on in the webinar. Now, as I mentioned in the opening, in this tumultuous world, prudent Canadian residents themselves may want to consider a backup plan. Because in response to the COVID-19, Canada has joined many countries in taking on huge deficits. This additional debt will undoubtedly require additional tax revenues to service. And as the Canadian government cannot get blood from a stone, it will undoubtedly continue the tradition of targeting wealthy Canadians for more revenue, egged on by some populist tax the rich rhetoric, which is already being spewed. In light of this situation, it's not wholly surprising that one member of the Liberal Party would bring forward a proposal that Canada adopt US-style citizenship-based taxation. In fact, in April, the member for Nepean published a detailed policy proposal entitled "The Case for Citizenship-Based Taxation Has Been Building for Years, but with a huge budget deficits to come, fairer taxation is all the more needed." There are many who would say that it's highly unlikely that Canada will adopt a US-style citizenship-based taxation. They may be right, but if this does occur, the cost of damage to those who want to avoid this additional tax burden could be significant if they'd not previously acquired the insurance policy of an alternative citizenship to go along with their new tax home. And so the thing to remember is the time to get fire insurance is not after your house catches fire. And since fire is a distinct possibility, simple prudence would prompt all of you to implement all possible fire prevention techniques, which we're going to be talking about in this webinar, and a fire escape plan before the fire. And at the end of the day, money spent acquiring these simple precautions will be nominal compared to the potential financial devastation that may impact the unprepared. Thanks, Todd.
Thank you, David. Just to clarify and summarize some of the key points here, David, why would you say it would be important at this time, in light of some of the political instability, economic stability, to consider Canada as an option for people wanting to either protect their assets or their personal safety? Just in summary.
Canada is an immigrant country. The importance of having a bureaucracy that can deal with it quickly. Many countries don't have that. They are already responding to be able to deal with things under COVID-19. It is a large country, as many people found during the pandemic. Having a passport to a place that you had visa-free travel wasn't useful. You needed to have some type of permission, such as a work permit or a residence permit, to actually allow you to go to those safe havens. You look at different areas, such as in China and Hong Kong, the new security law, undoubtedly the Chinese government is using this as an opportunity to further extend their control. They've effectively moved what should have happened in 2047 to 2020. And a lot of people are reacting to that. If you look at places like Brazil or Mexico or India, which because of the social situation, they are not able to socially distance and they're not able to adequately put into place prevention categories for COVID-19, it's going to be devastating. And those countries are going to have to look at trying to get revenue to pay for that. And again, the only people that they can get revenue from are the wealthy. So the wealthy have to look at that backlash, not just from a taxation point of view, but from the society kind of turning against them. And the idea of taking care of your family, whether it's for security purposes or to prevent them from catching a deadly disease, is a natural thing, no matter what your wealth is. And it doesn't suddenly become an evil thing just because you have the means to do it more than other people in society. And it's that backlash that people really need to look at. You don't have that type of backlash to such an extreme degree in Canada. And so for all the reasons that it's an attractive jurisdiction and other places are becoming unwelcoming, Canada becomes very attractive in comparison.
Thank you. Lauren and I were chatting earlier today, as a matter of fact, and we were discussing the estate freezes and various different plans that some of those of you who are in attendance today have been implementing with our assistance. And one of the things that came up was oftentimes there's a lot of confusion over when, how, where to institute or implement certain types of planning. And one of the things that came up in our conversation is that the idea of trusts is intriguing. We've had so many clients over the years, in this case, business owners, often lawyers and accountants as well. A business owner say, what I'd really like to have is a family trust. Well, why? Well, obviously, they're interested in intergenerational tax planning, estate planning, and they understand that. But one of the things that we are maintaining is there's so many different uses of trust. To that end, I'd like to invite John McLeod from Barbados, who's going to describe to us how trusts can be used, what trusts are, what are the benefits, and also how trusts can be used in particular to provide a higher level of asset protection in Barbados versus Ontario. John, please.
Thanks, Todd. I'll talk not only about Barbados, but the use of trust generally, and I can talk about Barbados as a jurisdiction, but we're very familiar with a whole range of other jurisdictions where we administer trusts. But I guess I should start by saying there's been a dramatic spike in financial restructuring activity from around the world in recent months. Daily, we're approached by clients directly, by their lawyers, their accountants, financial planners, insurance planners even, all concerned about some of the issues that Dave L'Esperance raised, including how to take advantage of local and world economies in the wake of COVID-19. They're concerned about looming insolvencies in their own countries in many cases, including Canada, I might add. We've all seen the dramatic fluctuations in stock and bond markets, and finding the right investment strategy for their risk tolerance is important. And the increasing global instability, future tax increases that David referred to. And you know, in this world where our children move to other countries and live in other countries, many of our clients are interested in mitigating the high estate taxes and probate fees. And I guess most important of all, people are concerned about asset protection, as both Todd and David mentioned, not only for themselves, for today, but for their children and their grandchildren going forward. And for that reason, for the first time in their lifetime, many wealthy individuals and families are considering with some degree of urgency multi-generational tax planning, retirement planning, estate planning, and asset protection planning. And among the most cost-effective strategies used to manage all of these issues together is the use of an international trust, or for that matter, an international foundation. Trusts have been around since the 12th century in common law countries. And perhaps the reason why trusts are so popular today is the relative certainty of outcome that they provide, thanks to the large body of tax law and the sophisticated trust laws in many jurisdictions, and statutes of limitations in many jurisdictions protecting assets held in trusts and foundations from creditors. Now, most of us are familiar with trusts and their long common law history. However, just as a refresher, and to address Todd's point about what is a trust, let me describe a traditional international trust. A trust basically has four separate interested parties. The first is the settlor, who's the person who creates the trust, and usually the person that contributes to the trust, but not always. The second party is the trustee, who has a mandate, the sole mandate, to carry out the wishes of the settlor for the benefit of the third category, which are the beneficiaries. And as I mentioned, the beneficiaries could be children, grandchildren, charities, and so on. And the fourth and final party to a trust is the protector. And the protector is a person or a company which has the ability at law to remove and replace the trustee. And the protector is generally a close friend of the settlor. And that way, you know, if the settlor is not satisfied with the duties of the trustee, he or she can contact the protector and suggest a change of trustees. So, so that's the what. Let's talk a little bit about the why. And as Todd mentioned, in this webinar, we're going to talk about more international families. So a common request is from families living abroad who have children who live abroad as well. In this day and age, our children take flight and don't stay in their home country. They've moved to countries abroad for lifestyle reasons or personal reasons. But in many cases, they may be subject to taxes which are even higher than in their home country. And, you know, we talked about China, for example, or Hong Kong earlier, where the ambient tax rate is, let's say, 13%. And so if you've got a child who's moving to Canada, where the tax rate can be 52+%, or the UK or the US, where they're 37 or 40%, that may be a negative tax outcome if not properly structured. Now, fortunately, and we'll use Canada as an example, there are structures that will allow a foreign settlor to create a trust for beneficiaries living in Canada or the United States or Great Britain, where with proper planning, the income tax will drop from whatever it is today to zero. Many of us have heard about this sort of inbound immigration planning, in Canada, often nicknamed a granny trust. And a granny trust is a structure that allows the settlor to put assets into the trust for the benefit of the children. Distributions of capital can be made to the beneficiaries in Canada for multiple generations. Neither the trust nor the distributions will be taxable. And if you happen to have children who are resident in a country that has estate taxes or inheritance taxes, the same concept can be employed where the trust, where the beneficiaries will not have a vested interest. And so therefore, in in the US and the UK, where the estate and inheritance tax rates are about 40%. And I should remind us all that that 40% is not an income tax rate, that is a capital tax. And so think about it. If you've got a $10 million estate that you want to leave to your child, before it gets there, or if you leave it to your child and before it gets to your grandchildren, in both the US and the UK, you can be subject to a tax of up to 40%. So of your 10 million, 4 million comes off the top. So I guess the message there is that estate taxes at those rates can wipe out a family's fortune in 3 generations or less. The other area that I think we should talk about is people and assets moving from one jurisdiction to another. And Lauren will pick up on some of the tax concepts of this later, but people who have generated significant wealth may have cause to have concern about remaining in their home country for all of the reasons that Dave Lesperance mentioned. And again, the use of a trust or a foundation seems to be the most flexible structure or structures that can be used to give both a better income tax outcome, 100% asset protection if properly structured, and certainty of outcome for the benefit of children and grandchildren. We mentioned asset protection earlier. I don't know how many times I've heard somebody, a client, say, look, I'm not worried about asset protection for myself, but I am certainly worried about it in the next generation, either because of the nature of employment of the next generation, or even more often, I hear about a potential for a matrimonial properties claim. And settlors and founders, generally speaking, want their children to benefit, not the spouse of their children. And the third area of why is business owners wanting to build wealth abroad. And again, they may want to become a resident of another country, or they may just want to invest in another country. And in doing so, they don't want to necessarily pick up the estate tax liability, the income tax liability in that new country. Rather, they would like to have their assets grow in the most tax effective manner possible. And I think this is a good point maybe to shift to Lauren to talk for a minute about some of the strategies that we use on a regular basis to accomplish some of the income tax strategies that we employ to achieve some of those goals.
I'll just briefly talk about a couple of examples. Let's start with the Granny Trust. John and I are working on a file now where a wealthy Latin American is establishing a trust for a family that are currently living outside Canada but planning on moving to Canada. And the desire is to create a new business opportunity. And this is very much today a virtual business. So there'll be no physical premises, but all of the production and distribution, marketing, customer care, it's all going to be done digitally. So the funding will be into a Barbados trust, the beneficiaries of which are the Canadian children and grandchildren. The businesses are going to be companies owned by the Barbados Trust, generally outside of Canada, and there'll be services provided from Canada by the children of the settlor, but control will rest with the Barbados corporate trustee, John's company, Edicus International Barbados Limited. Under that structure, we can protect the assets as the business grows in value and the growth is accruing to the beneficiaries of the trust. This is, again, an irrevocable discretionary trust. So even though the children and grandchildren in Canada are the beneficiaries, none has a vested interest. We are protecting the assets as they grow, and because we are structuring it under the umbrella of a tax-free trust in Barbados, we achieve very significant tax benefits, both with respect to income as it's earned, not taxed in Canada currently, and when distributions are made, we carefully will structure them to be tax-free capital distributions, not income distributions. So that's one example. I'll hand it over to Todd now, and we can talk about some other structures involving ways in which we can protect assets with or without trust.
Well, thank you, Lauren. I think before we jump into a very, very useful diagram that will help individuals to see a methodology that will provide for investment in a stable economy in a tax-effective way that achieves asset protection, I'll take just a moment to point out three things briefly for you. One of them is often we see trusts constructed improperly. We see a number of problems that not only can cause problems from a tax point of view, but also may not be fulfilling the individual needs of the beneficiaries, as well as the intent by those who may have control over the trust, the trustees. And perhaps we see in situations that can be rather damaging to the family's affairs. So what we're suggesting is that you do bring in experts. We see banks and accountants and other individuals that are constructing trusts that ought not to be in existence. That's one thing. Second thing I'd like to point out is that the use of trusts is not by any means aggressive. As a matter of fact, the trust law is deeply rooted in antiquity. First record of a trust relates back to Roman law, where there was the ancient Roman Empire, where there was an individual on his deathbed, and because he was not able to bequeath the assets to his children and spouse, since they were not citizens of Rome, he was befriended by an individual who offered to take care of his assets in order to provide for family members. Well, I'm sure you're going to guess what happened. The individual decided to abscond with the assets and ended up allowing the wife and the children to simply exist in a state of impoverishment. The individual was punished by the Emperor of Rome and therefore was one of the first records in common law about the existence of trusts. Trusts go back a long time. Trusts are not entities per se. A trust is an arrangement. It's one person who's essentially holding the assets for the benefit of another for a specific purpose. And this is an area that we'd like to help you with. We'd like to help so that we make sure that your affairs are properly structured and to make sure that the objectives can be fulfilled. I'd like to go into a structure that we have developed for the purposes of assisting individuals who are considering entry into Canada. And this particular slide that I'm demonstrating right now essentially shows how an individual who is resident, say in a Latin American or South American country, is able to enter Canada, possibly individually as themselves as far as migrating, second to invest in Canada. This is a situation where we have an existing company in a South American country. And what we've done is we've set up an Ontario corporation, and we have established an executive secondment agreement between the existing corporation in a South American or other Latin American country and an Ontario corporation. And Canada is then becomes an entry point where these individuals can gain access. Individuals from the US or Mexico are able to gain entry fairly easily in order to obtain a work permit, as David had mentioned, even at the point of entry into Canada. That is an option. It isn't necessary. The individuals do come to Canada. David will elaborate as to why it might be good to have that as an option and he's mentioned that already. We then establish a limited partnership here in, say, Canada, perhaps in Ontario or some other province in Canada, British Columbia, Alberta, what have you. And we would also set up two other parties. One of them would be a general partner. And in this case, this individual would be responsible for managing the affairs, the day-to-day affairs and requirements of the limited partnership. And then we'd set up a limited partner, which would be a segregated cell company. And the segregated cell company would allow us to be able to aggregate investors in order to provide for an opportunity for individuals to invest into this partnership here in Ontario. The tax consequences are, rather, the tax benefits are profound. We would also look to have individuals in Canada who are not resident in other countries invest in a corporation whereby a Barbados Trust would be the controlling shareholder. Lauren, I'd like to ask you to take the lead in describing the role of some of these parties and what the tax benefits are.
Sure. First of all, to understand why we're choosing a limited partnership, it is fiscally transparent. As we know, that there won't be any corporate tax. All of the profits and losses are allocated to the partners in this structure. 99% will go to the limited partner and 1% to the corporate general partner. And when we look at non-residents wishing to invest in Canada, if we had, this diagram shows it's available for Colombian residents. So let's say an individual wealthy Colombian was to become an individual limited partner, he or she would have to file a tax return in Canada, and in respect of ordinary income, pay tax in Canada at a 53% rate. We would rather not have that, but if we can, put several investors together in what I call a collective investment undertaking for administrative ease, try to minimize exposure to Canadian tax at the same time. And that's why we create the Barbados Segregated Cell Company as the single limited partner. All of the investors subscribe for separate classes of shares in this Barbados company. So let's say the first Colombian investor with $10 million subscribes for Class A shares. The assets and liabilities associated with the 10 million are kept completely separate from the assets and liabilities associated with every other class. So another Colombian investor could subscribe for shares. The B shares or the C shares, they're all segregated from each other to provide significant asset protection.
I think it's also important to note that in the seg cell company, all of the cell owners or shareholders do not have to come from Colombia. They can come from anywhere in the world.
Very much so. And we've done this with Middle Eastern investors, European investors, Asian investors. It's a flexible structure. Both the limited partnership can be set up anywhere in the world, and we would anchor the limited partnership with the segregated cell company in Barbados. So now we look at the contributions by the investors by way of share subscriptions in the Barbados company. And many Latin American countries, for example, do not have tax laws similar to what we have here in Canada. We call them the FAPI rules, foreign accrual property income, which could result in a Canadian resident with a foreign investment that's a passive investment, having that income attributed back to him or her in Canada. The rules in Latin America are more limited. So if we had one Colombian investor putting more than 50% of the capital into the segregated cell company, they might indeed be faced with attribution rules. But if we can fracture the ownership of that Barbados company so nobody has more than 50% of the capital contributed, we have a very favorable tax result. There is no attribution back to the home country. In other words, we have to look at the Canadian tax, if any, and Barbados tax, if any, but no home country tax. So to give a couple of quick examples, let's say that the partnership invests in shares of a mortgage investment corporation, a MIC in Canada. Its purpose is to lend money to Canadian residents and earn regular interest income on mortgages, not a participation feature, just regular mortgage interest, and pay all the surplus out. There's no tax in the MIC. When the dividend is paid, it's deemed to be interest income. And under the international withholding tax rules of Canada, there is no withholding tax on that interest when it's paid from a Canadian debtor, the MIC, to a non-resident lender dealing at arm's length. In other words, the 99% corporate limited partner here, the Barbados company. And the interest income is exempt from Canadian withholding tax. When it is received by the Barbados company, it'll be taxed at about 2%. And so there is a very favorable tax structure where the wealth can be accumulated, not attributed back to the home country, and not subject to a challenge by creditors. Except for one important element that I haven't yet dealt with, and that is who owns the shares of the Barbados company. When it's a wealthy Colombian or other Latin American, creditors either inside the family or outside creditors from the business can sue that wealthy individual and potentially seize those shares. But instead, the diagram shows the potential for setting up a trust in Barbados. And again, the purpose is asset protection. In civil law countries, because trusts are not recognized, one would look through the trust to see who the legal owner is. Let's say the Colombian wealthy investor would be considered the owner. In Colombia, for tax purposes, if there were attribution, which in my example, there is not. But the benefit of having a corporate trustee as the legal owner under a trust arrangement for the benefit of that family is that a subsequent claim, either by an unhappy spouse of a child where there's a matrimonial breakup, or a business creditor suing, will not be able to enforce the claims in Barbados for key reasons. First of all, it's a discretionary trust. And so none of the family members has a vested interest. They're all contingent interests. Second, there's a 3-year limitation period. So if the claim doesn't come to the trustee and the Barbados courts within 3 years of establishing the trust, the Barbados courts will not entertain the claim. And thirdly, a Barbados court, even with a valid claim, can only enforce orders in respect of Barbados assets. And so we are going to be very careful in the way we structure things. Certainly on the far left of the diagram, you'll see that we set up the structure for a Canadian company, and we're doing more and more estate freezes involving Canadian companies owned and controlled by the family, but voting control lying with the Barbados Trust. And again, that gives added asset protection. So overall, we would favor the establishment of a Barbados Trust for this purpose. And I'll just very briefly give an illustration of how that works. There was a wealthy matriarch in Mexico several years ago who established an irrevocable discretionary trust. In this case, it was with a Bermuda corporate trustee, similar to the one that John runs in Barbados. And the family were named as contingent beneficiaries in the trust. The lady died, and a nephew found out that in Mexico that he was a beneficiary. And he knew that under Mexican law, there were forced heirship rules that gave him some entitlement in law to his aunt's estate. So he sued for that. And when he tried to launch the claim in Bermuda, it was rejected. The Bermuda courts said to the nephew, yes, your inheritance laws apply in Mexico for a Mexican who dies owning assets. But here, all the assets are owned by a Bermuda irrevocable discretionary trust, and your Mexican laws do not apply here. They dismissed the claim. The similar results would obtain from any of the countries we're talking about that even have civil law and not common law traditions, because we're setting up a trust in a common law jurisdiction where the laws are very favorable to the debtor as opposed to the creditor. So overall, what we show in this structure is an ability to invest, having non-residents invest in Canada through a limited partnership that minimizes Canadian tax, provides asset protection. At the same time, if desired, we can help the non-resident with migrating to Canada to get a backup plan, second residence, and finally, to give the ultimate asset protection benefits, we would recommend establishing a Barbados trust to hold the shares of the segregated cell company, the corporate limited partner. That's the overall structure and the benefits that flow from that.
Well, thank you very much, Lauren. That was very insightful. I'd like to just take a step back for a moment and say that, we are not suggesting that it's a one size fits all. This is one example of customized planning that can assist wealthy investors inbound to Canada. We had various conversations over the last few weeks with individuals from various different Latin American countries, individuals who are well connected in places like Iran and Russia, also Hong Kong. And some of the discussions we've had have been along the lines of, well, we're interested to purchase real estate in Ontario. And to make it very, very simple, from a tax perspective, the difference in paying tax at 53.53% as an individual is profoundly inferior to examples such as what we're describing. And I'm not sure that it was obvious, but in the scenario that we've described, the tax, since Lauren had mentioned that if you're paying interest or what's deemed to be interest out of Canada to a non-resident, in this scenario, there's no withholding tax, and the total tax is only 2%. I want to make that clear, which is quite profound. Not only that, but on the bottom left, when we're talking about Canadian investors, a side effect of having achieved the asset protection by utilizing a Barbados trust creates a non-Canadian controlled private corporation, which generates yet another tax benefit. And that is, rather than paying tax at the general tax rate, and which is obviously different than the rate that Ontario or BC or Alberta companies or any other company in Canada would pay tax on active income, we're talking about tax on passive income, which is at a rate of about 50.03% currently, depending on the province. Having said that, the tax rate would only be 26.5%. One of the members of our group had prepared an analysis that showed millions of dollars of difference in, say, an individual who's investing $10 million over, say, 20 years. If you're being taxed at 50% versus 2%, I think the numbers speak for themselves. So these are tools in a toolbox that we would intend to use to assist different individuals that are considering a more stable economy, more political stability, and quite probably a way that you can protect your assets in a way that may not be available in the country in which you're domiciled. I would say that we'd like to maybe get a bit more clarity on the top right section. And I'd call on David Lesperance to amplify on how this would work and why an individual may want to entertain this, even though they may not be thinking of leaving to come to Canada this time.
Sure. Thank you, Todd. So if you look at the upper right-hand corner, we call it an investor executive secondment agreement. The immigration status that the person is seeking is a work permit. Another term for this is an intracorporate transfer. And basically what we're doing is we're transferring founder/executive from non-Canadian corp to a related Canadian corp that we're setting up. We can do this very, very quickly. I mentioned earlier on in Canada, you can do very quickly. That results in a work permit for the spouse, student permits for the children. And what a lot of people particularly in the lockdown and then the restrictions are finding is that simply having a visa or visa-free travel to a country isn't enough, that they need a greater status. And this is what this is. It has the advantage of, while the work permit and student permits can be endlessly renewed and are good the first time for 1 year and then later on are done in 2-year chunks, they don't automatically come with any type of physical presence requirement. It's an arrow you can have in your quiver should you ever want to, if there's another second or third wave and you want to go somewhere that is dealing with COVID or a pandemic or a hurricane or security or whatever better than your country, and you want to come to Canada, you can do that. If you're going to spend more than 6 months in Canada, it's at that point that you start, as you approach that time, that's when you start talking to John and Lauren about doing some pre-immigration tax planning. But if you don't spend more than 6 months, you could simply have this in your back pocket should you ever need it. And there was one of the questions I took a run at answering in the chat line, that if Lauren and John want to have a look, they can comment also. But right now, as Todd mentioned, one of the major problems for immigration and movement around the world is that embassies and consulates are closed because of COVID. As a result of what until 6 days ago we used to call NAFTA, is now USMCA, for American and Mexican clients, we can put this together and actually process it when they arrive at the airport. And so this has been a great boon for, particularly we've had a lot of Mexican clients who, because of COVID and resulting security issues, et cetera, and just concerns about how the government there is dealing with that and that backlash that I mentioned, are getting this in their back pocket.
Very good. Thank you, David. I think I'll call on John McLeod for a moment, just to briefly describe. And we've had individuals comment, well, how could I possibly trust a company I don't know in Barbados to have a role in administering my wealth? How can I be sure I'm not going to lose my money? How can I be assured of security if that's my goal? Then after that, we'll have David speak to some of the issues involving the investments that Lauren referred to. So John, if you could briefly answer that question, please.
Sure. Well, it's obviously not the first time I've heard that question. The concept of taking a significant chunk of your personal net worth, shipping it off to a trustee in a foreign country that you don't know, and expecting them to do as you've asked them to do. But the reality of these situations is that there are lots of protections built in the structure and in the law that surrounds it. So although the trusts generally should be irrevocable and discretionary to give you asset protection, and often that affects the taxation as well, you have the ability to appoint a protector. So if you don't think the trustee is acting the way they should, you can remove and replace the trustee with a new trustee. You could, for all intents and purposes, make yourself the trustee if you wanted through your protector. Not that you probably want to do that because it would defeat the structure, but you could find a new trustee. That's number one. Number two is that generally speaking, we look to the settlors to prepare a letter of wishes describing how they'd like the trustee to handle matters not only while the settlor is alive, but thereafter. And the third thing is, the reality is that in many of these cases, the assets never leave the home country. Title might leave the home country, but in a lot of estate freezes, for example, of a Canadian corporation, for example, the preferred voting shares remain in Canada, and the trust picks up the equity shares as part of the estate freeze for boring old-fashioned estate planning purposes and the deferral of taxation. So, and the other thing is that trustees have a duty only to the beneficiaries. They cannot benefit themselves in any way. And the courts over 900 years have been pretty clear in decisions in that area. A trustee has a higher duty than the ordinary man with regard to their role as a trustee if they're a professional trustee. So there's really not a whole heck of a lot of risk assumed at the trust level, provided that you've done the right planning, you got the right advice, that you've got good documentation and all the checks and balances are in place. There should be little to no risk for the current generation or future generations. I hope that sort of summarizes it.
I'd like to add just one quick comment. We're often asked to compare setting up a trust in Barbados with a corporate trustee, such as John's company, Edicus, or what about just a regular Ontario trust, typically with individuals as the trustees. Very often it's the husband and wife and possibly what I call a friendly stranger, who are the individual beneficiaries, or sometimes it's just the entrepreneur, trustees. Sometimes just the entrepreneur individually who declares himself or herself the trustee or the friend as the trustee. Now, what happens if there is misconduct, bankruptcy, car accidents, all sorts of things happen to individuals? And so we have to look at that reality and think about the potential loss of assets. Todd gave the example of what happened back in ancient Rome, but it happens in modern Canada. There are lawsuits all the time about individual trustees or executors under a testamentary trust misappropriating assets, misconducting themselves, and so on. But if there is a licensed corporate trustee, as there is in the case of Edicus, with regular oversight in the jurisdiction to ensure that everything is being done properly for the benefit of the beneficiaries, that trust that company that as a trustee is going to be there for the long term. And if there ever were a problem where, let's say, that trustee went bankrupt, the regulator would make sure that the assets were preserved and transferred to another licensed corporate trustee, which would not be the case in Ontario. If individuals steal the money, there's no regulator. There would have to be the beneficiaries going to court to try to recover it. Expensive, difficult, if not impossible. So that's one of the main reasons why a Barbados corporate trustee is superior to a typical Ontario trust.
One of the other questions we sometimes get is, well, what happens if the law changes in Barbados, or Barbados adopts a communist regime or something? Not that that's likely to happen after 300 years of British tutelage, but should that happen, we generally build into most trust deeds a flee clause, where even within the Atticus group, we could transfer the administration of the trust from Barbados to New Zealand or Hong Kong or one of our other trust jurisdictions.
Well, thank you very much. I think there's two messages to take home here, folks, from what both Lauren and John have described. And one of them is, as John said, it's a question of title ownership of title, not not direct control of assets necessarily. As an example, a corporation which is established in a province in Canada would typically be the director, and the only director would typically be the entrepreneur, the individual who has control of these assets would be a business owner or the family. Secondly, despite the fact that the Barbados is a Commonwealth jurisdiction and there's reciprocity with respect to courts recognizing an order, say from the province of Ontario or British Columbia, since the courts would respect that kind of an order, they wouldn't be in a position to make an award since there's no assets, as John said, in Barbados. Simply, there's title ownership, and the assets would remain in Canada, and the assets would essentially be controlled, whereby the individual is generally the only signing authority at the bank account. So there's really a question here of whether or not the tax savings and the asset protection makes it worthwhile. And I think it does. John and Lauren had described many different benefits of this. And Lauren had talked about the fact that in the case of investments such as a mortgage investment fund, or a corporation rather, there's some benefits where tax can be reduced perhaps to only 2%. To that end, I'd like to call on David Yanaglu to elaborate on that kind of investment option, and also to give investors who are migrating personally or perhaps investing in a limited partnership structure somewhere in Canada, to give them some idea of the kinds of investments that might be available to them. David Yanaglu, please.
Thanks, Todd. Yeah, in thinking about all of these issues that John, Lauren, Todd, and David Lesperance have talked about, thinking about families that are foreign to Canada and families that are within Canada, but mainly families that are foreign to Canada, they're looking to protect their wealth and use this inbound partnership model. There are diversified and bespoke investment opportunities that one can choose. And some of these are the real estate and mortgage investment vehicles. We've heard Todd and John and Lauren talk about mortgage investment companies mix. And these and REITs are a great way to invest in GTA real estate, which is recognized the world over as robust and generally very stable, even in moments of turmoil, without the need to get into onerous property management and other complications. And also these provide very generous returns. And right now is a great time. It's a historically beneficial time, especially from an FX rate standpoint, for non-CAD holding investors when one looks at CAD to USD. And it's an opportunity to mitigate volatility risk as compared to actual real estate investments. And it's in a regulated industry, and it leads to a path for Canadian residency. There's also investment in gold and precious metals. And gold specifically is a very stable, relatively stable asset class, and a strategy used to mitigate volatility risk. And it's in the case that's provided through this inbound partnership structure, it's physically secure. It's held in the Royal Canadian Mint and also provides a path to Canadian residency. There's also through Argentum Asset Management Inc. in both Barbados and Switzerland, there is available globally diversified investment strategies. And I'd like to say that at this point that all of these kind of investment opportunities are achievable through everyone's bespoke and distinct investment goals. And lastly, there's also private equity participation, specifically in the high tech space. And in addition to regular private equity investment, there is also a private equity financing opportunity, both for traditional financing and non-traditional financing in excess of 50 million USD. So lots of great opportunities that are available through this inbound partnership. And I kind of ramble through them, but I'm not sure if Lauren or Todd, you guys want to add any tax color to these?
Sure. I'll add a couple of points. Let's look at private equity participation, for example. This limited partnership, again, is fiscally transparent. And so if there are shares of a high-tech company that are acquired, that grow in value, and that are disposed of, we have an interesting opportunity from a Canadian tax point of view. So long as the principal value of those shares is not derived from Canadian real estate, these shares are not taxable Canadian property. And so when the capital gain is realized, it's tax-free in Canada on the private equity participation. And because 99% of that benefit goes in favor of the Barbados corporate limited partner, well, eureka, Barbados doesn't have any capital gains tax. So we have achieved a very significant objective. We've preserved the wealth and done it on a very tax effective basis for the private equity deals.
I'll also mention that, where we talk about tax that is as low as 2%, whereby the limited partnership in the structure described is the aggregated, where the aggregated investors in a sense reside, that would assume that there's no distribution. The interesting part of it is that dividends paid from the Barbadian company is not subject to tax, other than the fact that, as Lauren had mentioned previously, there may be rules that are akin to our FAPI rules that may cause taxation. Depending upon the country of origin, it may be possible that where you have a trust established in Barbados and you have dividends that are paid to the trust through the trust rather to a beneficiary, that there may be in some instances a possibility of additional tax advantage, but that will be very specific. So again, we're giving you some highlights and some ideas on how all of this might work. We wanted just to talk a little bit about some questions we've had in the past about a traditional estate-free, since we're talking about trusts and since we're talking about tax reduction, we're talking about paying a lower rate of tax on passive income with respect to income earned on investments and so on. The option is available where a corporation, a Canadian corporation, can invest in parallel to this limited partnership structure. And in this particular instance, what we've done here is we've demonstrated something that we've talked about before, but we have 3 key points that we'd like to help the audience to better understand, because last time several people in attendance had contacted us and said, we really didn't get that. Can you explain it again? So we promised we'd slip this in just to provide better clarity. In this particular instance, we have an operating company, which is a Canadian controlled private corporation. And as such, the corporation shares are eligible for the lifetime capital gains exemption. The company may be eligible for small business deduction as well, depending upon the amount of taxable capital. In this particular instance, the entrepreneur has frozen his shares through, say, Section 86 or Section 51 share conversion, just a basic rollover, causing the common shares that grow to be exchanged for preference shares that have a stated value that don't change. We have then issued new common shares in 2 directions. One of them is to the Barbados Trust, where we have all of the future value being accrued, and where the trust itself would essentially hold shares that would not control the underlying company. We have created another conduit, if you will, and that would be to another Ontario corporation. This Ontario corporation that would be holding shares of the underlying active business company, in this particular case, we would choose to have that company foreign controlled. In other words, we'd issue the common voting shares to the Barbados Trust, which means that we are shifting control depending upon the company, and in very elaborate structures that we see that have 5 times more boxes and triangles, we're able to achieve things such as preservation of the lifetime capital gains exemption in the active business or other companies in that group, while creating a conduit that allows us to move money tax-free, dividends tax-free, an intercorporate dividend into the capital corporation in such a way that this corporation can now enjoy the lower rate of tax. And the fundamental and bona fide reason that we're doing this is because of the fact that we are attempting to create asset protection. And the side effect is definitely significant in that we're able to achieve non-CCPC status. But there's no liquidation value to these shares. The purpose of these shares that we're issuing to this this Ontario company, it's a Canadian company, but it's controlled by the Barbados Trust. And the purpose of doing that is to make sure that we have a place that we can better achieve asset protection on a tax effective basis. Well, the future value, the liquidation value of the company, so say we froze at $1 million and the entrepreneur's shares never will go higher than $1 million. What we've done is we've then caused all of the future growth. Say the company grows to 10 million. That means the $9 million of value would be attributed to the trust. And of course, this is deemed to be under the NERT rules, the non-residence trust rules, a Canadian trust, which means that the trust itself is filing a T3 tax return. So please don't misunderstand this and mistake this for something aggressive. It simply is not. You think of the Guerin case, you think of various different cases that have existed that have called into question the efficacy of trusts outside of Canada. And generally speaking, what the planners are trying to achieve is to take advantage of lower tax rates, which we're not. The tax rates that we're utilizing are the tax rates that exist in Canada. And the trusts themselves, we're not trying to cause the trust to be deemed anything other than a Canadian trust for tax purposes. I would like to turn this back to Lauren again. Lauren, you have a case study when we have about 8 minutes left in our program, and we'd like to have some time for questions. So perhaps we will conclude by having Lauren talk about the case study, and then we'll deal with some questions from the audience.
Okay, I'll briefly explain the facts. We've chosen an example that is typical of many wealthy families. We were approached by the professional advisor for a wealthy Hong Kong family. Mr. Wu owns real estate, and he's been a successful businessman living in Hong Kong, but he has 3 children. One moved to the US, another moved to Canada, and a third moved to the UK. And he's tired of and concerned about life in Hong Kong and worried about the unrest, and is considering a semi-retirement, at least buying a property abroad, perhaps in the UK or Canada. And he wants to be closer to his children and grandchildren, and have a place for him and Mrs. Wu to visit. He also is worried about the fact that his assets are principally located in Hong Kong, so he wants to diversify. He has enough cash to live on for the rest of his life, but he's complaining about tax that he and his family have to pay. So he wants to give some money away right away to his children to reduce his estate. But he's concerned about these children. He's unhappy with one of the children who has married and is having matrimonial difficulties. So here are the basic facts. What then are the key issues that come out of those facts? So the first bullet point that I've listed is residence for tax purposes. If Mr. Wu leaves Hong Kong and comes to Canada, as John mentioned earlier, potentially he's facing a personal tax rate increase from 13% to 53%. Similar concerns, maybe less of a gap, would apply in the US and the UK. In each case, pre-immigration tax planning is very important to minimize tax. So briefly, what we would do for Mr. Wu, we've done for others who come to Canada: set up a Barbados trust and a Canadian holding company that would acquire, let's say, ownership of his businesses and properties in Hong Kong or elsewhere. And that company in Canada would be controlled by the Barbados Trust. Therefore, it would not be a Canadian-controlled private company, and investment income would be taxed not at 53% as an individual pays or 50.2% as a Canadian-controlled private company pays on investment income, but rather 26.5%. Very important. The second bullet point is risks associated with the children's spouses. So when Mr. Wu is concerned about, let's say, a son-in-law making spurious claims against the family's assets, the Barbados Trust is an ideal solution to be able to say all of my, Mr. Wu's family members are contingent beneficiaries in the trust. And that could be a good defense, particularly in the way I've described it earlier with that Mexican family and the nephew, against a future challenge. Moving to the third bullet point, gifts made during a lifetime. Well, let's assume that Mr. Wu, from his point of view, can make a gift tax-free, but it depends on, first of all, which country the individual is going to. If it happens that if a child were to go to Spain, they impose tax on the recipient of a gift as opposed to the party making the gift. The other important consideration is, well, if a gift is made, then the donee of the gift is the absolute owner of it. Therefore, any income earned on that gift, let's say it's a portfolio of securities, will be taxed to that child at the high rate in the particular jurisdiction. And if the child dies, the assets will be part of that child's estate, subject to all sorts of claims, including from the taxman. Instead, if the gift were made to a trust in the way we've described, we can avoid a lot of those problems. The next bullet point is death taxes, and that's a natural outgrowth of the discussion about gifts. If the Wu family members, for example, the child living in the UK, were to be the personal owner at the time of his or her death, that the 40% inheritance tax could apply, whereas if it's a Barbados trust, it will not apply to the assets in the trust. Income taxes payable by the children, the next bullet point, is something that I've mentioned earlier. The trust can minimize that. And then finally, the overall objective of this whole seminar and of this, or webinar, and this example, assets of the children exposed to creditor risks. It's not just Mr. Wu that we bring to his attention, but the risks associated with the children and grandchildren, whether they're in businesses, the professions, holding assets that could be subject to seizure, or matrimonial claims in their own families down through the descendants. The trust structure can help Mr. Wu and his family. And so I think Todd, we've come to the end. Over to you.
Thank you very much, Lauren. Again, ladies and gentlemen, we really appreciate your attendance today. I noticed that we have about a minute left and we have a lot of questions. I think what we'll do is maybe just try to answer one or two of them, and the rest of the questions, certainly we can endeavor to answer offline. And if our group can be of assistance in either domestic tax planning, estate freezes, trusts that are established for purposes of achieving asset protection, multiplication of capital gains exemption, purification, inbound investors who are looking for security and asset protection. There are many solutions that our group has. I would like to take just a moment as well to announce that our group is going to be launching a new entity that is designed to assist with inbound investors as well as family office services that we believe we can provide a wider breadth of assistance using some of the individuals here in this team. Without further ado, this will be announced later, but without further ado, we'd like to ask a few questions here. There's one that asked a question: to comment on the risks of forming a Barbados trust for shareholders of a CCPC in the post-COVID era. This individual who's asking the question goes on to acknowledge that there's a treaty that exists between the two, but he's suggesting that possibly CRA could be using a more than vigorous effort in the way that they look at it. He's suggesting that, or really asks the question, what prevents Canadian tax authorities from negating benefits received by a Barbados trust in the context of issuing shares of a CCPC to a trust held in Barbados? Who would like to take a run at that question?
I'll answer it first, and then everybody else can jump in. Let's keep in mind what Todd said earlier. This is not an aggressive offshore tax play. This Barbados trust is deemed to be resident in Canada. It will be compliant filing T3 returns. That's the first thing. So there's not a lot of mileage in the CRA taking a run at a regular Canadian trust. The other important aspect, again, that Todd mentioned earlier, and I'll reinforce, the assets in that Canadian company, the surplus that might remain there, or in our earlier diagram, be paid up to the Capital Corp, owned or controlled by the Barbados Trust. Those assets remain in Canada and under the control of the family. They will establish who the directors and officers are of all the Canadian companies underneath the trust. The trust is purely a holding function. We don't expect there to be any significant income flow going up from the Canadian companies through the trust. It may be in the future that their distributions are appropriate in consultation the trustee will have with the family, but that's exceptional. The whole idea is to grow the assets under this type of structure.
Very good. So we'd like to ask everyone to watch your emails, please, because we'd like your feedback. This educational program has been ongoing for several years, and we're seeing the same friends coming back time after time, which is nice. And we're also seeing that a lot of you have shared this information with contacts, perhaps on your email account or just other individuals that you're familiar with. And we appreciate that. And we'd ask you to continue to spread the word as our group continues to provide education on a number of subjects. We're going to be having a session dealing with litigation matters, including civil litigation, tax litigation, litigation over trusts. We're also going to be having a number of other sessions. There are 10 sessions that will be released soon with dates covering a multitude of different subjects that we're looking forward to, including a lot more emphasis on Canadian domestic tax planning and various different opportunities. But again, on behalf of our entire group, we'd like to thank our loyal audience for the support and staying with us. And please do not hesitate to reach out if there's any way that our group can help you, either in your own practice or if you're a business owner, we could help you directly as far as achieving some of the benefits that have been described today. Without further ado, we're going to close the program, and thank you to our expert panel as well.